Thank you very much, Mr. Chairman. First for Mr. Kobach. Both you and Mr. Giddens, in your previous testimony, I believe, stated that no matter the exact size of the shortfall, speaking of segregated funds, its probable size is significant and will substantially affect the trustee's ability to make a 100% distribution to former MF Global Inc. customers. Is that still your opinion today? Good. And thank you for just the yes or no answers. They're very rare around here, and we really do appreciate it. I know that you do not want to speculate while your investigation is still underway, but based on Mr. Duffy's testimony and other reports, it seems highly probable that customer funds were transferred out of segregated accounts and commingled with MF's own funds. I don't think anybody's doubting that at this point. Probably to meet margin calls on European bond positions. I mean, is that okay? Assuming for the moment that that is in fact what happened, it would mean that the missing customer funds will never be found in some overlooked or unreported account somewhere, as had been hoped for by many customers when they first discovered that a substantial sum of money was missing from their accounts. Because if the money was being used to back those bond positions, we know that those bonds were sold in mid-November. Correct?
That's our suspicion as well. Doesn't mean we're not looking at it carefully. We stay up late at night thinking
we take yes for an answer around here. Thank you. According to a detailed report in the Wall Street Journal, those bonds were sold at a loss and at an additional discount, or bargain price, so to speak, to buyers that included J.P. Morgan Bank and George Soros. Have you seen the reports in the Wall Street Journal?
I've looked quickly at the Wall Street Journal, yes.
All right, thank you. I know you're not responsible for dealing with the bankruptcy proceedings for MF Global, but is it true that once the wall has been breached between customer segregated funds and corporate funds, the money could have been moved via a whole range of intracompany transactions, internal repos, etc., to virtually any part of MF Global or to the counterparties who were financing those bond positions?
If the question is it possible, I believe it's possible. Whether it happened or not, we don't know. That's what we're looking at.
Possible is fine. That's just, it strikes me that what we have here is a situation where the segregated funds belonging to MF Global, including the honest, hardworking families in my district's money, were misappropriated to support a way too big speculative bet by Mr. Corzine and the board at MF Global. Since the bet was closed out at a loss in a transaction that I believe needs to be investigated further, we could be looking at an absurd and totally unjust situation in which monies have been taken from customers' pockets only to find its way into the pockets of big bankers and hedge fund managers. I know that you need time to do your work, and you have no right to interfere with the bankruptcy proceedings. That's the responsibility of the judiciary branch, obviously, but if this committee can find a way to help reverse the travesty, obviously that's what we want to do, and that's in large part why we're here right now. It's just essential, obviously, to protect the sanctity of segregated accounts if we're ever going to restore confidence to the commodity markets and the U.S. markets in the future. Final question. Mr. Capano poses a really, really interesting question. Let me just frame this a little bit differently. Is it true that J.P. Morgan was one of the main depository banks for customers' segregated bank accounts?
I believe it was a depository, but any funds that I'm not actually sure it was a customer bank, and we've gotten from virtually all the domestic depositories the funds they were holding. It's really the foreign funds are our problem. Okay.
And they were also the providers of the main line of credit to MF Global, over $1 billion.
There was a substantial line of credit, I think, to the holding company, and I think it was on behalf of a syndicate of banks, but J.P. Morgan, I believe, was the lead of that syndicate.
Okay. And they would probably be unable to recover all of those loans if customers were made whole.
I don't know whether that's true or not at this point.
Possible?
It's possible.
Probable?
I would say possible.
All right, we'll settle on possible. J.P. Morgan and Soros purchased the MF bonds in mid-November. Is that correct?
That's what I read in the paper.
That's what the article says. By then, everyone in the world was well aware of a missing $1.2 billion in customer funds. Correct?
I certainly was aware of it. I assume others were.
Do you think they should be concerned about the possibility of buying stolen goods?
I really don't know what the circumstances of those sales
Mr.
were.
Baxter, do you? Yes or no would work.
There are provisions in law for a bona fide purchaser, and those transactions, while I don't remember as vividly as perhaps I wish I did, Jim, and you may help, but I think the bankruptcy court might have approved some of those transactions. And I assume the bankruptcy court would not have approved transactions if the bankruptcy court felt they were violative of law.
Mr. Ketchum?
I know no more with respect to the liquidation, Congressman, than that. I do have some recollection that there was approval of those transactions from reading the story, but I know nothing more directly.
Okay. Mr. Duffy?
I have no other knowledge other than what I read in the paper also, sir.
Mr. Cook?
I have nothing further, sir.
Mr. Bergovitz?
I can't really comment on where the money or the transactions really may have gone. We're trying to trace these, and we're trying to get the money back.
Do you think it would be reasonable for customers to expect some clawback, starting with Mr. Baxter?
Again, there are protections in law for transferees who are bona fide purchasers and have no knowledge that the property they're acquiring has in any way tainted in title or otherwise. And I don't know the facts, Congressman, as to what purchasers may or may not have known.
If the purchase had been made after everyone was aware you got $1.2 billion missing, I mean, I think even the most extraordinarily naive person would say, there's a $1.2 billion missing here somewhere. I wonder why I'm getting such a bargain on this.
And perhaps Mr. Kobach is more
all right, we'll go to
more
Mr.
familiar
Kobach.
to answer this than I have, but we have worked in a couple of bankruptcies together, and oftentimes it's important to be able to liquefy some assets, particularly if the market is declining and those assets are losing value. So you shouldn't jump to the conclusion, Congressman, that a sale is necessarily bad for the bankruptcy estate. It wasn't for some of the estates that I acted as liquidator for, and I suspect that Jim would agree with me on that.
Well, and again, I'm trying to think of customers first, just like the customer advocate is supposed to think of customers first. And I can't help, as far removed as it is, I can't help but be reminded of Madoff, and I can't help but be reminded of how effective the clawback has been for some of those poor people who were exploited by Madoff. And I'm just trying to get an idea if there's possibility here. Maybe there's not, but it's just an interesting concept brought forth. Can I just get the response from the others, Mr. Chairman? I think they're all going to plead ignorance on this, but...
Well, let's be lightning answers here, please.
Okay. I don't know if I'd call them clawbacks. There are legal theories that you can avoid transfers, you can attack transactions. That's what we're going to look into. I'm not sure if the transaction you're talking about is specifically our transaction, but it's certainly something we'll be looking into. But we have to find a basis, a cause of action. If we find it, I can assure you we will pursue it very diligently.
Okay.
I neither have the facts nor the bankruptcy expertise to be able to speculate, Congressman.
I don't have the expertise, but I will say one thing. I think that customer segregated funds are the ones that are missing. They do not have SIPC protection or other things of that nature. I believe that they should be first in line in any circumstance whatsoever to get this money back.
Thank you, Mr. Duffy. I do too.
I don't have the specific facts, and I'm not a bankruptcy expert. I think your original question was, would it be reasonable for a customer to look for clawback? And I think if I were a customer, I'd want
every possible avenue to be pursued vigorously. I don't know whether there's, I don't know the technical details of the law here to be able to know whether there's hope that that would occur here.
We are absolutely committed to getting customer money back to the customers.
Thank you.
Thank you.